Good evening. For those of you who are online, good evening from Chicago. In a beautiful spring day in Chicago is an oxymoron. And thank you for joining us in the room and online. For those of you who don't know me, I'm Luigi Zingales. I'm the faculty director of the Stigler Center, a faculty member of Chicago, and one of the organizers of this conference. Tonight, we're delighted to host a keynote conversation with the chairman of the Federal Trade Commission, Andrew Ferguson, and the University of Chicago professor, Eric Posner. Thank you both for being here and making the time. Before we begin, a few notes. First of all, we are on the record and live streaming, and we will post all the conference video on the Stigler Center YouTube channel. If you have questions for the speakers, we will address them in the last 15 minutes or so. Please wait for the microphone before speaking so that everybody also online can hear your brilliant questions. As usual, views expressed by guests are their own, not those of the Stigler Center or the University of Chicago. We hope that you will join us for the remainder of our conference tomorrow, which will continue in live stream. Also, we invite you to check our website for more details, as well for the Stigler Center publication, promarket.org, and the Stigler Center podcast, Capital Isn't, which I co-host with Bethany McLean. And now please allow me to briefly introduce our speaker. Andrew Ferguson is chairman of the U.S. Federal Trade Commission since January 2025. Prior to that, he was a FTC commissioner since March 2024. Before, he served as Virginia's Solicitor General, chief counsel to Senator Mitch McConnell, and as a Republican counsel on the U.S. Senate Judiciary Committee. He also practiced law at several Washington, D.C. law firms. And then our own Eric Posner is the Kirkland & Ellis Distinguished Service Professor of Law at the University of Chicago. His research interest is very broad, but includes antitrust and constitutional law and financial regulation. He's also a prolific author, and his most recent book is How Antitrust Failed Workers. Between 2022 and 2023, Eric served as a counsel to the Assistant Attorney General for Antitrust. And now I turn it over to the speaker. Thank you very much.
Good evening. Thank you for that kind introduction. I consider it an honor and a privilege to address such a distinguished group. The purpose of this conference is to discuss whether increased market concentration negatively affects our marketplace of ideas. There are two assumptions hidden within that objective. The first is that it assumes that the marketplace of ideas is something we value or ought to value. And the second is an assumption that increased market concentration could undermine that value, whatever it might be. If that weren't a possibility, this would be a pretty short conference. In my comments this evening, I want to provide some brief reflections on each of those assumptions. What value are we trying to preserve in promoting a marketplace of ideas? For Oliver Wendell Holmes, the answer to that question was simple: truth. In one of his most famous dissents, Justice Holmes argued that the best test of the truth of an opinion is its widespread acceptance by individuals engaged in a free trade of ideas. Just as success in a competitive marketplace can demonstrate the utility of a product to consumers, so too a consensus forged by the free and open exchange of ideas is the best test of the truthfulness of that consensus. But Justice Holmes did not end there. For him, the truth arrived at by a free trade of ideas is the only ground upon which an idea should find its expression in our law. In other words, the marketplace of ideas is valuable not only because it helps us to discern what is true, but also because it promotes a political order where consensus is forged by the exercise of public persuasion, rather than imposed by the exercise of public power, or by the collusion of actors wielding private power, or, as we've seen recently, the collusion of public and private power together. Characteristic of Justice Holmes, this opinion was personal, pragmatic, and progressive. Holmes had nearly died fighting for the United States in the Battle of Ball's Bluff. The great contestation of slavery ended with that war, but, as he put it, he realized that time has upset many fighting faiths. He believed that political consensus could and should be won not on the battlefield, but in the free trade of ideas. For Holmes, to embrace persuasion over power stands at the very heart of our theory of the Constitution, obliging us to be eternally vigilant against attempts to restrain or limit the free exchange of ideas among citizens. If Holmes is correct, freedom of speech, which makes the marketplace of ideas possible, is a value deeply woven into the very fabric of our constitutional order and our society. If market concentration negatively impacts our marketplace of ideas, it is because it limits rather than expands the free exchange of ideas among a citizenry. Now, the marketplace of ideas is, of course, a metaphor, and as such, it has its limitations. For one thing, the widespread adoption of an idea does not necessarily make it true, nor is an idea's limited adoption necessarily a bar to its truthfulness. My own view is that there are objective truths in the law of nature, discoverable by the application of human reason. And those ideas are true even if they are believed in advance by a very small minority of the community. But history reveals that those truths are not always readily discoverable, and even once discovered or revealed, what those truths pretend for any particular community at any particular time or place is not always obvious. Reasonable minds can and do disagree about them. Within the boundaries of objective truth, then, there is much room for debate, and that is where the idea of marketplace of ideas matters the most, both for discovering the truth as part of the process by which human beings apply their reason to nature, and for determining how to apply those truths prudently to the circumstances in which a political community finds itself. When we speak positively about the necessity of a marketplace of ideas for an open, free, and democratic society, we're not thinking about the market for PR men, Madison Avenue, advertisers, and other paid purveyors of propaganda, which all too often includes members of the legacy press. Rather, we are thinking about the free, open, and informed exchange of ideas among ordinary citizens, motivated by a desire to seek the truth and serve the common good of their community. And not only that, we are also thinking about a truly public forum through which each citizen, not just society's elites, have equal capacity to express their own opinions, to have them heard and responded to by others, and for the consensus emerging from that exchange to have a genuine effect on the public policy of the society in which the exchanges take place. I'm thinking about the vice president providing a detailed response to a policy criticism by a random anon on X. I'm thinking about the fresh perspectives one finds among academics and journalists who no longer have to depend on institutional gatekeepers that have long abandoned their core principles to educate, to inform, and to challenge abuses of public power. I'm thinking about an X thread on foreign policy written by an informed citizen lacking any credentials from the elite gatekeeper institutions which actually can influence public debate among policymakers. I'm thinking about the dissident physician who takes to social media to challenge his colleagues' consensus on a public health crisis, and whom history proves to have been absolutely correct. I'm thinking about the capacity of the individual citizen to amplify, through sharing or reposting on online platforms, his or her own opinion, cause, or policy, and to coordinate civic action to effectuate the realization of that policy into law. These are all examples of how the digital revolution has opened new avenues for citizens to participate in the political and civic process. Like any other, this revolution has its promises and its pitfalls, and we have to collectively decide how to balance the two. Yet if the greatest promise of social media is that it facilitates a mass expansion of the capacity of the citizen to engage in a free and open exchange of ideas, its greatest pitfall will forever be the temptation of social media companies to short-circuit that marketplace by censoring and limiting opinions with which they, or others, all too often the Democrat Party, don't agree. And because they occupy a new sector of our economy, these platforms often benefit financially from a relatively lean set of laws and regulations governing the conduct of their businesses. Social media companies and the free exchange of ideas they facilitate are therefore vulnerable to outside parties who seek to create, by censorship and control, a more favorable information environment to advance their own social or political agendas. It should be obvious to everyone here that if the social media space is highly concentrated, with incumbents facing little to no competition from rivals, it will be easier for platforms to engage in censorship, whether on their own initiative, in collusion with each other, or at the behest of left-wing public officials, regulators, advertisers, or other DNC interest groups. In other words, increased concentration can negatively impact the marketplace of ideas because it facilitates a variety of censorious practices. And censorious practices, whether carried out by state actors, private aggregations of power, or a combination of the two, is inimical to the free expression that makes our marketplace of ideas possible. While I think such practices do some symbolic harm to our political culture by undermining the value of free speech in society, they also constitute a deliberate abuse of a social media platform's market power and a potential violation of our antitrust laws. When social media companies practice censorship, they inflict harm not just on those users whose opinions are excluded altogether or limited in dissemination, but also on any user who is attracted to the platform because it facilitates a genuine marketplace of ideas. To be sure, antitrust law cares about the mistreatment of the speaker, but it is no less concerned with the injury inflicted on the user who wishes to ingest ideas on a platform. If part of the attractiveness of a social media platform is that it facilitates a genuine marketplace of ideas, a highly concentrated, less competitive market will make it easier for social media companies to degrade the quality of their product through censorship without facing any competitive consequences. If a social media platform can make its product less attractive through censorious practices, violations of its terms of service, or through excessive advertisements, and if it can do so without a proportionate loss in its customer base, there are strong reasons to suspect that it is not operating in a competitive environment to the detriment of its users, which could be a violation of the antitrust or consumer protection laws, depending, of course, on the facts. For this reason, the Federal Trade Commission recently requested public comment on the experience of users whose access to social media platforms has been denied, demonetized, or limited due to the content of their post, their affiliations, or, most terrifyingly, conduct that took place off the platform. To my mind, the best way to preserve some of the promise of social media as a digital marketplace of ideas is to acknowledge that the quality of its product depends in part on its commitment to free speech to its users. Consumers and content creators want a platform committed to free and open exchange of ideas. If they wanted left-wing apparatchiks to curate or inspect their ideas prior to public dissemination, they would content themselves to sit in a think tank lecture or inside a university classroom, or they could read The Atlantic. Of course, not all consumers or producers of ideas on social media are seeking the truth by engaging in diverse ideas and clickbaits. Users have diverse interests on social media. Some are sating their curiosity with clickbait. Others might be doom scrolling. They might be trolling, or they may be seeking consolation in the values of their own beliefs or prejudices. In those cases, we are not faced with a consumer or producer of ideas who intends to engage in the free marketplace of ideas. But that doesn't mean that the prospect of engaging in a free and open exchange of ideas is not part of what attracts even those users to a social media platform. You can't doom scroll without an abundance of pessimistic perspectives. You can't troll without there being individuals whose opinions you see fit to lampoon. And you can't find consolation in the validation of your own beliefs without accepting that others do not share those beliefs as you do. Every user of social media, from the low-brow meme makers to the self-anointed policers of misinformation, is invested in the preservation of free expression on social media. Because users of social media prefer it as a form of free expression, and as such a facilitator of a marketplace of ideas, high concentration in the social media space leading to censorious practices poses an identifiable harm to consumer welfare. While we cannot always assume that consumer welfare will dovetail with the preservation of important constitutional values like the freedom of speech, it is a fortunate coincidence for an individual like me who is committed to freedom of speech as I am, that the vigorous enforcement of antitrust laws can promote this important social and constitutional value. I have emphasized tonight the dangers of censorship in a highly concentrated media market. I have not spoken about the dangers of, quote, misinformation, end quote. This is not only because I categorically dismiss elite and Democrat hysteria over misinformation altogether, but also because I believe that a highly concentrated social media space generates far more opportunities for elite and left-wing manipulation than it does for populist so-called misinformation. One prominent left-wing scholar once described manipulation as the exercise of power in secret, unknown to those who are influenced and lacking any kind of public legitimation. As Missouri against Murthy revealed, when a society combines high concentration with opacity surrounding content moderation decisions that control the dissemination of information on social media, you have a recipe for elite manipulation of the public under the guise of combating misinformation. Fortunately, the solution to manipulation and misinformation in the social media space is the same. To ensure that social media platforms meet consumer demand for a product that protects freedom of speech, thereby facilitating a genuine marketplace of ideas through which we might test the truth of our own claims as well as those of our fellow citizens. Thank you, and I look forward to our discussion.
Thank you very much, Chairman Ferguson. Your thesis is admirable in two ways. One is that it's so responsive to the topic of the conference, so I'm sure people appreciate that. And then the other is that it's extremely clear and crisp. And so let me summarize it like this. First, consumers want a free exchange of ideas. They go onto social media platforms in search of them. Second, the platforms, and I want to ask you about this, don't actually do that or haven't done that. Instead, they've engaged in what you call censorious conduct or content moderation, or they limit speech, however you want to put it. And then therefore, you're arguing that, I guess maybe presumptively, or you're claiming, just as a matter of fact, the platforms aren't actually engaged in competition. So on the first, is it true that consumers are actually, or users are actually going onto social media platforms seeking the free exchange of ideas? You mentioned that some go on to like have fun, to troll other people, maybe to torment or bully people. It also seems to be the case that people don't often want to actually hear the ideas of people, who differ with them to a great deal. So, what's the basis of your view? It sounds like an idealized view of how people behave rather than the reality.
I do think it's the reality. Even people who are pretty strictly aligned with one side or the other do derive pretty obvious pleasure from engaging in good or bad faith, it depends, with ideas from the other side. I mean, I meant what I said. You can't troll unless there are people around that you disagree with. And so even someone who goes on just to, bully, I'm not going to say harass, but even if someone is going on just because they want to pick on people they disagree with, you have to have access to those ideas, number one. Number two, I think the reaction to the censorship epidemic of 2020, the public reaction, sort of revealed a strong preference to in favor of having access to ideas that you agree with, that you disagree with, or that you're not sure about. I think sort of the success of X after it was purchased by someone who had a relatively open commitment to free speech, especially after everyone promised it was going to fail when it was originally purchased, is pretty good evidence that there's a preference for this. Now, it's also obvious that I don't think consumers want sort of a no holds barred access to everything, including categorically illegal stuff. It's definitely true that people like receiving some content more than others. But I think it's equally true that the average consumer does not want a platform where particular ideas are just categorically excluded. And if they did, you would expect, there to be platforms where the curation was aimed exclusively and expressly to just one side or the other. I guess Blue Sky is a potential example, which is not exactly taken off. I also think, a lot of consumers began engaging with these social media platforms when they were quite openly touting their commitment to free speech and a free exchange of ideas. And then over time, that commitment somewhat eroded. And one of the things that the FTC asked in this, initial phase of the investigation, asked consumers to weigh in on was, what was your understanding of the terms of service for these platforms when you signed up on them? And then were you being kicked off of these platforms inconsistent with their terms of service? And a lot of these platforms had often very flowery commitments to free exchange of ideas in their terms of service. And a lot of consumers think that they didn't live up to them. And President Trump in 2020 actually issued an EO asking the FTC to look into this. The FTC did not, but that's one of the things that we're examining now.
Right. And I do want to ask you about that. But at first, a number of people have complained that Musk has kicked them off X or deplatformed them or whatever the term is. And then I'm not on X myself, but I gather that you can't really avoid Musk's tweets or X's or whatever they're called. So, I mean, so he starts off with, I think you're right, commitment to freedom of expression. He loosens the moderation rules. But what should we think about what's happening now? Is this evidence that there's not competition in this type of social media? The fact that he's deplatforming people?
So I don't know as an empirical matter whether he's deplatforming people. I simply don't know. I'm sure some people, as is true of every platform, are removed for violating terms of service. I also think it's very obvious that people are allowed to say and express ideas on X that you are not allowed to on other social media platforms. I mean, Facebook, for example, still has a vaccine misinformation policy.
Mm-hmm.
And then in terms of, avoiding Musk's tweets, it might just be my algorithm that gives me ready access to them. He's also one of the world's most famous men and is a important leader in the most important government on earth. I don't think it's terribly surprising that the algorithm would be, putting his ideas in front of people. I don't think that suggests like a competition problem, nor do I think, the removal of any particular user does. But I think, insofar as the argument is there wasn't sort of widespread idea-specific censorship, especially in 2020 and 2021, you're just asking me to not to believe my lying eyes.
Sure.
There quite obviously was.
I want to come back to this point about exchange of information. And then one of the speakers earlier today reminded us network effects. And you would think that if people want to exchange ideas, be exposed to new ideas, you'd want as big a platform as possible.
Yeah.
And that seems to lead you in the direction of monopoly. So how do you reconcile your view that the best use of a platform is exchange of ideas among as many people as possible, but your desire as well to have competition in the social media sector?
Yeah. So I do not think that a particular platform's propensity to censorship is categorically an indication of monopoly power, or is categorically an abuse of market power. Honestly, the sort of like social media problem that has concerned me more before the purchase of X was the sort of eerie similarity of the censorship policies across all of these platforms, including, like the almost identically coterminous decision to eject Parler from the online world entirely at the exact same time, to get President Trump off of all the social media platforms within a couple hours of each other. The risk of collusion, which is made easier by an absence of competition, is what concerns me more. And I've written about this, but I think, insofar as I don't think you said this, but if you did, just to clarify, the mere fact that a platform conducts censorship is not itself an indication of market power. The thing that concerned, I think, a lot of Americans in 2020 and 2021 was that all these platforms seemed to basically move in lockstep on a variety of social issues. And like the reality of this became even clearer once we had Discovery and Murphy against Missouri. They all were adopting the same policies, often in consultation with the government or with, lists of experts, and they all were using the same experts. That concerns me the most, is the idea of a handful of market participants. They're just going to agree on what contours their product will have. And when your product is the exchange of ideas, that's extremely dangerous.
Right. And I did want to ask you about that. So, but you quickly went from and as an antitrust lawyer, I'm sure you're thinking about this, but you quickly went from the fact that they were all doing the same thing at the same time to the possibility that they were agreeing with each other to do the same thing at the same time. And as you know, as better than anybody else here, as well as anybody else here, parallelism occurs all the time in markets. It can be prices, it can be quality, it can be all the rest. It can be all kinds of things. And so to use the examples you gave, one you mentioned pushing Trump off the platforms. This was immediately in response to the election controversy. Response.
Maybe. I
just mean as a temporal matter.
Right, but no, it happened after. It does not follow it was a response. It is entirely possible that they talked to each other about kicking off the world's most famous man. And I think that's the issue I'm concerned about, is if there are only a handful, that sort of collusion is very easy. Or if there's a willing partner in the government to sort of like communicate amongst the various platforms what the rules are going to be. It's very easy to do if there's only a small handful of them.
Right. But so you're worried that they might have entered into an agreement, but you don't have any evidence. Is that
no,
right?
and nor did I say that. My contention is, same with the ejection of Parler. These decisions being made coterminously could just be conscious or unconscious parallelism. Could also be the result of collusion. Collusion is made easier if there are fewer participants, and that is the concern that I'm discussing.
Okay. You also mentioned just now you're concerned that the government during the Biden administration pressured the social media platforms to what censor, as you would put it, limit what people have been saying about what people were saying about COVID. Now, that doesn't sound like an antitrust problem. At least, do you think that's an antitrust problem? If the government says to these platforms, "Look, you're saying things on or allowing speech on your platforms that are causing people not to get vaccinated, with the result that this epidemic is going to get much worse." Is that an antitrust problem, or is it a different kind of problem, or is it not a problem at all?
I think it's a problem, and it isn't necessarily an antitrust problem. So I think Murthy itself revealed two things going on. There was pressure applied. The court said it wasn't coercive for First Amendment purposes, but there's definitely pressure, consultation, collusion between the platforms and the government. There also was repeated references to the record of all the platforms consulting with private outside experts on what the rules should be. That is potentially an antitrust problem if there's an agreement among them that we're going to use these experts to help us set the rules. Even if the sort of collusion pressure from the government isn't an antitrust problem, it is a problem for a civic society, and it is a problem made easier if there are fewer market participants. If there's a wider smattering of market participants, it's harder for the government to get on the horn with everyone and pressure them equally. It's easier basically to buck the government because there are more people. It's harder for the government to apply pressure across the board. There's just a handful of these companies that the government has to pressure. It's just easier to pull that off. And even if that's not an antitrust problem directly, like that conduct isn't an antitrust problem directly because of Pennington or state action or whatever, I don't think it follows that we throw up our hands and say, oh, well, antitrust laws can't address this directly. That is a problem, and it is a problem made easier by concentration in the market.
Yeah, I read the Murphy opinion, and I guess I just had a different impression. I'm curious. Maybe I read Alito's concurrence, which sort of lays out the strongest case. And what I got the sense what was going on is you have a bunch of government officials probably panicking, talking to Facebook and a bunch of other these social media platforms and saying, "Look, there's a pandemic going on. People are dying. There's this misinformation being circulated, which we think is causing some people not to get vaccinated, which of course will harm other people if through contagion." Facebook, please, stop allowing people to share this information, it's causing as much harm or more harm than other types of policies that you have against bullying or harassment or what have you. Now, that just sounds to me like the government, like, very strongly trying to encourage people in the private sector to act in a way that would advance the public good. Is that pressure, or is that sort of unacceptable pressure in your view for the government to say to these independent institutions, we want you to do that? Or is there something else going on?
So I think it depends on sort of whose version you believe. I don't know if you read the district court opinion. The district court's view was this wasn't just, hey, do us a solid or do the country a solid. It was like, do it or else.
Yeah, what is the or else? That's what I didn't get. Like, what was the threat, the implicit threat, however you saw it?
I think it's the same threat that a government can always potentially inflict on any marketplace participant, which is we can make your life difficult. The regulators can show up, they can audit, they can investigate, they can cost you a lot of money, and the path of least resistance is do what we say. I mean, this is not dissimilar to the issue the Supreme Court confronted with the New York financial regulators, calling up people and saying, quit doing business with the NRA or else. And the or else is just, we have a tremendous array of investigative tools. Those tools are expensive when applied to you, even if we don't win at the end of the day. So knuckle under. And, you know, the court's conclusion for state action purposes was it wasn't sufficient to transform the social media companies into arms of the state. I just don't think it follows from that sort of doctrinal nicety that the problem isn't government officials backed with potential coercive power, formal and informal, calling up social media companies and saying the following ideas are to be prescribed, prescribe them. And, you know, having worked in the government a fair amount, I think your view is either very charitable or maybe a little naive about what happens on a phone call between a private company and its regulator.
So the government shouldn't call up private institutions and tell them, do that, stop saying this, or we're going to punish you.
I do generally think the government should not threaten private people with punishment because of things they're saying, unless they are criminal. Yeah.
All right, good to know. Let's talk about the advertiser boycott issue. Also, you said you've said it before that you're worried about. You think that advertisers colluded or might have colluded to boycott social media platforms that displayed speech that they didn't like. Could you tell us more about that?
Definitely did not say they did collude. I said
they might have, yes.
Yeah, if that this risk is real and needs to be confronted and taken seriously. I mean, look, like part of the way that people who have ideas get them out there is they make a living by promulgating ideas. You are one of them. You get this, you know, incredibly protected job at the University of Chicago to sort of say whatever you want. Other people participating in the marketplace of ideas can say what they want as long as they can get the eyeballs to pay attention to them. And part of the way that you sort of make sure you can keep getting the eyeballs is advertising. And this isn't just true of social media platforms. This is true for a huge array of just individual speakers who have views both acceptable to the elites and dissident. Bloggers, YouTubers, people on X, all over the place. Part of the way that they get their ideas out there and they can afford to keep getting the ideas out there is if they can attract advertisers. If advertisers get into a back room and agree, we aren't going to put our stuff next to this guy or woman or his or her ideas, right? That is a form of concerted refusal to deal. The antitrust laws condemn concerted refusals to deal. Now, of course, because of the First Amendment, we don't have a categorical antitrust prohibition on boycotts. When a boycott ceases to be economic for purpose of the antitrust laws and becomes purely First Amendment activity, the courts have not been super clear. It's sort of a we know it when we see it type of thing. But the concern I raised in that concurrence with which I am deeply concerned is if advertisers either get in a room together and say, we're not going to do advertising next to this idea, right? Or they say, we're going to agree that this third party decides which ideas get advertisement and which don't. We're just going to let them do it, right? We are going to dry up the idea because we are drying up the person who has the idea's ability to make money off of that idea. And unless those people can get tenure, they need to keep attracting eyeballs because that's how they make a living. And drying up the advertising will dry up the idea. And so that the risk of an advertiser boycott is a pretty serious risk to the free exchange of ideas.
Just parenthetically, having tenure does not guarantee you any eyeballs.
Yeah.
I'm afraid, but we write for very small,
That's right.
just a few pairs of eyeballs. But again,
Although having gone to law school, I know they pay a lot to see and hear you. So
yeah, well, that's true. Again, I just want to press you on this a bit. We see a parallel conduct. We see a bunch of advertisers who are worried about their brand. And as rational economic actors, they don't want their advertisements to be on a platform that people associate with stuff they abhor, whether on the left or on the right. And so just seeing them pulling their ads from platforms that host offensive speech in whatever way, it could be just speech that the advertiser itself doesn't like. That's not a problem. It's only if they get in the back room. But when we talk about advertisers, we're talking about thousands of countries, thousands of companies around the country or around the world. There's no back room that they could all fit in together. Is it plausible at all that they engage in collusion? Or you mentioned also that they consulted with third parties, but it would seem to me, this is just business as usual. There are third parties out there that study brand management and how people react to how the association of an advertisement with a particular type of speech might affect business. What's the basis for actually trying to investigate in this kind of setting?
So can they all get into the back room and agree, having represented trade associations? The answer is yes. Have they? I don't know. No one's looked at it. At least, no one has publicly looked at it. But is this a possibility? Of course, number one. Number two, there are lots of advertisers. They tend to use a small handful of advertising agencies to make a lot of these decisions for them. There also are a lot of advertisers, but there aren't that many huge advertisers. And a decision by a bunch of huge advertisers to cut off access could have massive downstream economic effects on speakers who need access to advertising. But again, I don't think you're saying this. The fact that there is, coterminous identical conduct, this is true across all of antitrust law, does not mean there's an antitrust violation. But where there is smoke, there is not always fire, but there might be. And the whole point of having the antitrust enforcement agencies is when you see smoke, at least take a look. And I think, this could have been for a number of reasons, but one of the most prominent, you can call it brand safety managers if you want, was GARM. They confronted a single antitrust lawsuit from X and dissolved almost immediately. And it doesn't follow necessarily that they were committing the antitrust violations that they were accused of. But I do think that this risk is sufficient enough, and if it got really bad, would dry up enough access to ideas that it is incumbent upon the antitrust enforcers to take it seriously. And if they think there's something there, to look at it.
Okay, I have one more question, and then we're going to take questions from the audience. So please get your questions ready. You talk in your remarks. You mention this kind of ideal of people exchanging ideas on platforms, and my question is, and you've said, basically you said you don't like censorship, but you've also acknowledged that that there need to be there's some kind of regulation. Or am I wrong about that? And this strikes me as an important question because of your willingness to infer from limitations on speech that there might be a competitive problem. So what is it? What is it? At what point do we become suspicious of a social media platform? So I assume you've said, I think, that they could like block illegal behavior like child pornography or something like that. But if they genuinely think that their users are offended by Holocaust denial or conspiracy theories or what have you, what are you saying that even if that if they implement any kinds of limitations, that's bad for society, it's bad for the marketplace of ideas, and it suggests that they must be driven by anti-competitive goals?
No, I do not think that the imposition of any limitations is
Right.
bad
So I
for
just want to ask you, yes, what are those limitations?
and I think it can vary from platform to platform, and I think, frankly, in a good competitive environment, we would expect some variation from platform to platform. Nor do I think that just the act of content moderation is itself evidence of a competitive problem. But if any company is doing stuff that quite actively drives huge swaths of its consumers off its platform, and doesn't seem to suffer competitive consequences, ad revenue doesn't come down, what have you, that is at least a suggestion that there might be a competitive problem. It doesn't, the FTC and the government generally, actually not generally, the entire government is not the censorship police, because it would be very difficult for the government to be the censorship police without winding up doing a lot of its own censoring. But I do think that if there are businesses who are doing stuff that drive either a huge swath of their users or their preferences off of their product, and that nothing seems to happen to them, they don't suffer any competitive consequences, they get bigger, they get more profitable, there's at least evidence that competition is not thriving in the space. But it can't be, and it isn't, that just because every time a company decides to censor or content moderate, whatever you want to call it, that the antitrust enforcers need to show up. I just disagree with what seemed to be the long-held position by many, which is that this isn't evidence of a potential antitrust problem at all. I think it is.
And just a quick follow-up, was it actually the case that when Facebook and other social media platforms increased the limitations on speech, that lots of people left those platforms?
People left. It also got use of these platforms became super politicized, which is exactly what Facebook said it was trying to. A lot of these platforms said they were trying to avoid. I mean, Facebook acknowledged in January of this year that it had been downgrading all political content, had been trying to keep it across the board suppressed. There's evidence that isn't actually what was happening, but it's sort of neither here nor there. It became this extremely political product at the same time, and they did not lose many users, even as the public impression and public polling about favorability of these platforms plummeted in 2020 and 2021. And that doesn't necessarily demonstrate, that isn't the proof that isn't proof in the pudding. It doesn't make the case. But when you are enforcing antitrust laws, you don't show up at an antitrust problem when the case is fully baked and you just go. You're constantly looking for smoke to see if there's fire. And in my view, this is absolutely smoke, at least in some circumstances.
Okay, questions? Yes. Yes, over there.
So thank you, Chairman, for your speech. And I'm very fascinated by your approach to collusion or potential risk of collusion that seems to be quite novel. And I really endorse it. If there is smoke, take a look. I think that last year in this conference, I was asking people around to say, there seems to be a coordination in not publishing the information about the famous Hunter Biden laptop. Why there was not an antitrust enforcement on this issue, because that's really a serious issue. And I hope that you apply the same rule across the board, because there are a lot of potential risk of collusion, a lot of cases where there is smoke. And if you take a look in all those cases, would be the most interesting 4 years ahead of us. Let me give you a suggestion, for example, because in a lot of industries, not only there are the trade association, but there are consultants that play a role in giving the same suggestion to everybody. A colleague at different university told me that he was in a former life a consultant and went to a bank and suggested this regional bank to increase the fees. And then the regional bank, what they did is actually recommended him to all the other competitors. So he went to all the other competitors and they all increased the fees. So, and unlike the case of newspaper where we maybe see the evidence, in the case of consultants, we don't, because they don't publish actually who they consult for. So I hope you're going to look at the smoke and you're going to ask all the consultants to publish the list of who they consult for, and you look into that. Thank you.
I didn't hear a question, but I'll I can comment on nonetheless. Yeah, I mean, look, so two things. My view of the antitrust agencies is that they're cops on the beat, and you're supposed to walk around the markets, and if you see something that looks like trouble, you take a look. You don't prejudge, but you take a look. On the collusion thing, obviously collusion under antitrust laws requires some agreement on something. But I mean, you know, trade associations play a valuable role, but there's a pretty long history of trade associations that can act as sort of third-party facilitators of horizontal conspiracies. You know, I think there is a risk that can be taking place in the advertising markets. It's definitely not the only market where there's a possibility of that. You know, I'm always interested in looking for the smoke. To be clear, sitting in Washington or even with our regional offices scattered throughout the country, we've got one here in Chicago I just came from, we can't see it all. And so part of the role of people like you is to like alert the agencies when something's going on. We get complaints of varying levels of politeness about things happening in the market, including from some people sitting in the room right now. And they are often very helpful because it won't be obvious to us, you know, as we're all sort of looking where we're looking about what's going on. So this is helpful.
Yeah. Matt's door. Oh.
Thanks. So thanks for the speech and the questions. I guess I have a question about your broad observation that consolidation can lead to certain forms of coordinated speech restrictions. One of the things that I've heard a lot of when I go out to LA is there's a lot of fear of talking about China, particularly because of vertically integrated streaming systems that are highly consolidated. You hear this, the government actually put out reports in the mid-2010s, and you hear it all the time. You haven't seen a Chinese villain in movies for a long time. There are a number of reasons for this. But how would you approach looking at a problem of consolidated, vertically integrated speech platforms, for lack of a better word, outside of the sort of partisan approach, but looking at something like Chinese control over Hollywood, which is more of a national security question?
What I said in my confirmation, okay, so it is not the role of antitrust law or of antitrust enforcers or frankly of government to ensure some particular quantum of competitors in a market. We're going to end up with central planning. It's going to be worse than whatever we have now. But I do think that we ought to care about consolidation independent of the particular doctrines of antitrust law, because it is much easier for government to control what you think, believe, and do, and what I think, believe, and do, if there are a limited number of suppliers above us. It's just much easier for them to coerce a couple people than it is a bunch of people, just categorically is. And that's true of any government. And I think vigorous antitrust enforcement that protects against consolidation and leaves like a variety of suppliers makes it harder for the government to coerce you and me downstream by coercing the people we rely on for stuff. how I would think about the particular problem of vertically integrated like movie studios and streaming services and China, I don't have a particular answer on that, just because, I think there are potentially like fronts to think about antitrust law and our competitiveness vis-a-vis like foreign rivals. That isn't generally how antitrust law has constructed it, although I do think there are like interesting antitrust theories about whether like a merger that would give a foreign government more control over a particular industry should matter to the merger analysis. Like I'm open to that prospect generally. It isn't, traditionally what antitrust law has said, but it's at least an interesting like line of inquiry. But I think my view is antitrust law its job is not just to be anti-consolidation and make sure there's a certain number of competitors. But if you've got vigorous antitrust enforcement, you can resist consolidation and therefore resist the coercion of the individual or of the family downstream from just coercing the supplier. That's the thing that makes me very nervous about a limited number of suppliers of anything. Debanking has become this like catastrophic problem in this country where people are being denied access to retail banking services on the basis of things they say or believe or affiliations. If you've only got a small number of very large banks and the government has a particular view on whether someone's idea should be permitted in the marketplace, it's a lot easier to drive that out of the marketplace if all you have to do is have the banking regulator call a couple banks and be like, we don't like people who have these views banking with you, which is almost exactly what happened in the NRA against Fulo case with New York's banking regulator, just calling financial institutions being like, you do business with the NRA, I'm coming for you. That is an easier maneuver to pull if there are a few number of people involved in the market. It's a lot harder if they are a wide variety of participants. And that is one of the reasons that I think even for libertarians on my side of the aisle, who are focused mostly on the relationship between government and the citizen, you ought to care about antitrust law, because the government has a hard time directly coercing 350 million people, but a lot easier at times coercing 6 or 7 suppliers that all 350 million of us have to interact with.
Yes, back there.
It's working.
Just wait for the.
So on the topic of speech, I appreciate your remarks. Other members of your administration have broadly suggested that there hasn't been enough crackdown on speech, particularly at protests on campuses and other forms of speech at college campuses. Now, obviously, you're an independent agency. You're free to express your own views. And I'm curious, I guess, whether we can take it you're with university leaders like Princeton's Eisengruber, who think it's important to protect freedom of expression of all points of view, no matter what, at places like college campuses.
I'm not sure exactly what the question was.
The question is whether you believe the freedom of speech principle extends to the rights of protests on campuses, and therefore you stand with universities and against other parts of the administration who have threatened universities and suggest that they should crack down on speech.
I am not aware of universities suggesting that there be a crackdown on speech. I am aware of the suggestion that universities should not make it so that students fear for their physical safety when they're crossing campus on the basis of their religion. And I definitely agree with that. I think that the value of free speech is fundamental to this society. But the right to speak does not include the right to intimidate on the basis of someone's religion, to harass, whatever you want to call it. So, I am quite firmly of the view that I'm a member of the most free speech administration of my lifetime, and I'm extremely proud of that fact.
Yes, right over here. Yes.
Oh, hi, this is Barry Lynn, and I agreed with a lot of what you said, and as an organization, our organization, a few years back, just as a for instance, we condemned Facebook for knocking Alex Jones off the platform. May he burn in hell. We condemned AWS for knocking Parler off. But but I have a couple quick questions. So, amplification by the platforms, because all amplification means that other people's voices are being obviously put down in the order at which they're being presented to an individual. Is amplification a problem? Is it a form of censorship? And then the second thing is, you mentioned the Biden administration during the pandemic from putting pressure on the platforms. Last August, at that point, former President Trump threatened in writing Mark Zuckerberg with life in prison unless he did the right thing. Was that a wrong thing for Donald Trump to do when he was running for office?
Is amplification a form of censorship? No, I think throwing someone off of a platform because of the view they express is a form of censorship. Also, not the greatest example of civic discourse to just shout out someone burning in hell. I don't love that. But I agree with you that they shouldn't be throwing off people, just because on the basis of the views that they articulate.
And the second thing about President Trump,
I don't remember him saying that, so I don't,
Okay.
have any
All right.
comment on that.
Over here. I have a question. Let's put it that way. So I think when the agency is considering entering into like new areas, and I think free speech would be one in the US, then potentially the institutional guarantees matter. So I wanted to ask you about your view on the independence of competition agencies in a context of actions as the one you discussed, that potentially there might be a smoke.
Sure. I've made my view on this extremely clear a lot. I think that the idea of independent organs of executive power is very difficult to square with democracy. When we vote for the president, we're voting for the person who's going to be in charge of the entire executive branch. I guarantee that almost no one in this room would want me to be able to wield executive power free of political accountability. I guarantee no one in this room would want that. And I don't think in a democratic society, any of us should want very powerful agencies like the FTC to be insulated from political accountability. And so my view is that any agency that wields substantial executive power in the name of the American people has to be answerable to the American people. And the way that the executive branch in this country, under our form of government, is answerable to the American people is through the election of the president. And so, my view, which I've said over and over, is that the president has the constitutional authority to remove commissioners of the FTC, including me. And I am extremely confident that when this gets to the Supreme Court, which it is, I guess, there right now, that the president's decisions will be vindicated as a question of constitutional law.
I think we have time for one more question. Yes, right over there. Mm-hmm. Just wait for it's right next.
Thank you. Andrew, can I ask you a question?
Sure.
So, as FTC commissioner responsible for protecting consumers and especially vulnerable populations like children from unfair practices, do you believe that it's in the public interest or in the interest of children themselves for our kids to be on social media platforms designed to capture their attention and monetize their data?
That is a good question. So, this is the subject of a roaring debate. The commission is going to host a full-day workshop on this question where we're going to bring in scholars and advocates in a series of panels and speeches and debates to address this question. I think it has become very obvious that the relationship between children and social media is not a healthy one. It's not healthy for them. It's not healthy for the country. I think there are very good arguments that target advertising targeted toward children is bad in every circumstance. Congress is going to have to make decisions on this, but I do think that we are headed towards a reckoning on the relationship between children and social media, and the effect that social media has on forming brains with a product that is designed to sort of get a dopamine drip going over and over and over again. And states are starting to address this. Congress is started to address this. Government, I think, even as under current laws, there are parts of this government can address. The laws that I enforced were written in 1914 and 1938. And the problem we're confronting is quite new. And so we need to be very careful about how we apply these old laws to new circumstances and not sort of just, blunder in sight unseen to address what is a real problem. But I do think it's a real problem. Clara Morell wrote the Tech Exit. I think it is phenomenal. It's also terrifying. She'll be one of the participants in our workshop. But like, this is an issue that keeps me up at night, is the relationship between children and social media, the difficulty that every parent in America has regulating their child's interactions with social media. My own view, stated at a relatively high level of abstraction, is that the most important thing the government can do is interpose parents back between children and social media. And that's the healthiest response, rather than sort of a government interposing itself directly between children and social media. But parents need help. Children get to interact with social media outside of their parents' presence almost constantly. Screens are everywhere in our schools, whether you like it or not. Even if you are a family who has cut off access to the screens to your kids, their friends' parents probably have not, and they'll have access to it there. I think government needs to do something about this, and I think the main thing it needs to do is put parents back in charge of their kids and make it easier for parents to interpose themselves between their children and social media.
Well, I'm afraid we're out of time. We're out of time. Sorry, but please join me in thanking Chairman Ferguson for joining us.